Yes. Yes.
And we are approaching the notion. Political influence versus with the application. Is shooting court notion is not matter. We have had first reality.
You are the appeal on behalf of whom?
Insurance company.
Insurance company. What is the ground for challenge?
Two vehicles involved your notion and entire and also two insurance company involved and entire liability has to be passed upon my insurance company.
So why should the award be stayed?
Yes, sir.
No ground for staying execution proceeding. There is no ground for staying execution proceeding. Pay the amount to the claimants. Yes. Call the list. Yes. Yes. Let the appellant appear. Let the matter be called out. Let the matter be called out.
Out of this,
Yes.
CLP 644 up to 580 information. It is for restoration of second appeal. Earlier CLP was allowed, but court fee was depositing CLP as such not restored.
The court fee was deposited
In earlier CLP and second appeal was not restored.
how court fee was to be deposited in the second appeal.
Court fee was wanting in second appeal.
Okay.
That was dismissed for the fulfillment. CLP was allowed and court fee was submitted in CLP as such no second appeal was restored.
So you have filed the court fee in the CMP, not in the first appeal, in the second appeal.
Yes.
But
Yes,
the valuation, the amount of court fee is the same.
Yes, Lord.
Give me a slip. Yes. Item number? Item number 1. Sudhir Kumar. Let the matter be called out. We are out of station. It's not a ground for granting adjournment.
From the resources, under the heading orders with effect, serial number 1, MA number 573 of 50.
You file a early hearing application and you will say that the counsel is out of station, you grant time. Yes. Yes, have you served the notice? Call the Assistant Solicitor General of India. Call ASGA. Immediately. you appellate, Union of India, you file an appeal, you file an early hearing application, and when the matter is taken up, the first case, it's Union of India, and when the matter is taken up, you pray for time. On the one hand, you file an application for early hearing, and on the other hand, you pray for time.
I'm just checking out there.
Yes, it's a Union of India, Railways.
Yes. I'm just seeking a small accommodation because of this change of the
I don't know, your regime may change, but that doesn't mean that the decree will not be executed.
But the point is that because of this intervening holidays, the fines were directed to be handed over. A small accommodation was given over.
Because a prayer has been made to adjourn this case. Full stop. Next prayer. An IE has been filed for early hearing. Full stop. When the matter is listed today, the time is being sought for. Full stop. Next para. This case is adjourned for 8 weeks. It is made clear that there is no stay of the execution proceeding. The Railway Claims Tribunal Ranchi is to proceed with the execution case. Let a copy of this order be communicated to the Railway Claims Tribunal Ranchi. Sorry. Both your IA application for early hearing and prayer for adjournment cannot go side by side.
The difficulty was because of
I don't
so
know.
many circumstances.
I don't know. There may be 100 circumstances. Yes.
Under the heading for orders, serial number 2, MN number 6 of 50, Mr. T.C. Jha for the appellant, Mr. Mohammad Yasir Arafat, Mr. Arvind Kumar Lal for the respondent.
Yes.
One plate has already appeared against officers assessed on 9 and 10 July, and the case has been admitted by order dated 23/7/2018. And we have
What is the ground?
the ground is contributing against because two vehicles, two motorcycles collided, and charge sheet taken both the
Maybe.
both the damage.
Is charge sheet a piece of evidence? I'm asking you, is charge sheet a piece of evidence?
After investigation, the charge sheet is
Is charge sheet a piece of evidence? By merely exhibiting the charge sheet, can you say the facts mentioned therein is admitted or denied, or it is true? If you take a plea of contributory negligence and merely exhibiting the charge sheet, is it enough in support of to support your plea of contributory negligence? Tell me.
grant of this case 6 lakhs we have deposited. We have already amount was 9 lakhs something. We were directed to deposit 6 lakhs we have deposited.
What is the evidence which you have brought on record? The GR is here? What is the evidence which you have brought on record as the insurance company? Notice?
Might have not appeared.
place this case under the heading for hearing on (23rd) Wednesday. Yes, or you want to Wednesday? You go through the LCR. 23rd. LCR दे दीजिए.
Serial number 3, MA number 43 of 50, Mr. Vijay Kumar Sharma for the appellant. Mr. Ashutosh Anand for the respondent.
Yes. No. Yes, limitation. How many days delay? 22 days delay. You heard the counsel for the applicant, have the counsel for the respondent. IE number 574 of 2015. There is a delay of 22 days in filing this appeal. The counsel for the applicant submits that the delay is not intentional, as the applicant number 2, who is looking after the case, was suffering from jaundice, he couldn't appear and file the case within time. File his appeal within time. Considering the submission of the appellant and after going through the records, I am inclined to allow this IE allowed delay condoled that this is under the heading for admission.
Serial number 4 with serial number 5, MA number 52 of 50 with MA number 1 of 50, Mr. Jharkhand for appellant in first case, Mr. Arora for appellant in second case.
In this case,
Arising out of the same accident.
same as and in my case, you watch it on just number 6 and 7. Notice you will directly to the published in your paper, your worship. I have sent the instruction. I have sent the draft copy, your worship. But recently I have received the instruction that it has not been noticed. Fresh,
Now fresh draft has to be given.
yes, on 6 and 7.
Counsel for the appellant, Mr. Jharkhand submits that the notices could not be published in terms of Order 5 Rule 20A of the CPC. Full stop. He prays that a fresh draft, he will supply a fresh draft. He requests that the office may hand over a fresh draft, fixing another date, fixing a fresh date for appearance. Considering his submission, the office is directed to hand over a fresh draft with a fresh date of appearance for respondent numbers 6,
6 and 7.
7 and 10.
10 will be made.
Hmm?
6 and 7.
6, 7 and 10. 10 is there. 6, 7 and 10. The draft should be handed over within 2 weeks to Mr. G.C. Jha. Full stop. The next para, after a learned advocate, Mr. G.C. Jha. Full stop. Next para, next line. Necessary affidavit after publishing the notice should be filed by the appellant. Full stop. This case after 8 weeks under the heading for orders.
Serial number 6, MA number 173 of 50, Mr. Manoj Kumar Shah for appellant.
not executed.
Anyone is appearing? Fresh वकालतनामा है किसी का? Just check it. On the last occasion, that is i.e. 24/11/2021 when the case was listed, Mr. Manoj Kumar Shah, learned counsel appearing on behalf of the appellant submitted that the appellants have obtained no objection from him and has taken the case file and has instructed him not to appear in this case. Full stop. Considering the said submission, this case was adjourned for 8 weeks to enable the appellants to file a fresh wakalatnama. Cutting line to enable one like that. On 24/11/2021, on the aforesaid submission, and finding that no wakalatnama was filed by no fresh wakalatnama has been filed by the appellants, not the appellants appeared in person. An opportunity was given to the appellants, and the case was listed after 8 weeks. Full stop. Today the case has again been listed. Full stop. The office has reported that no fresh wakalatnama has been filed, nor any substitution petition has been filed, as one of the has been filed also. Full stop. Considering the aforesaid fact, this case is dismissed for non-prosecution.
Serial number 7, MA number 195/50, Mr. Alok Lal for appellant.
Due to some personal difficulties which are not allowed.
This is an orders case.
Yes, but
Yes, Mr. Santosh Kumar, what is it? Why it has been listed?
since the office is long, it will not give the kind of.
Who is appearing on behalf of respondent number 3?
Normally, the invitation is given.
Let us see what is the ground.
There is the communication.
Counsel for the appellant, Mr. Santosh Kumar appears. Full stop. There is a delay of 80 days in filing this appeal. The grounds have been mentioned in paragraph number so and so to so and so. After going through the same, I find that sufficient ground has been shown to condone the delay. Delay condoned. Is this case under the ready for admission?
237 of 50, Mr. Ashutosh Anand.
Yes, we were. And the appeal of file was if there was a national ground for people with regards to get salary, gross salary, etc. And thereafter, the matter was referred to another manner, but the perhaps to civil to get like I have already given my recommendation for withdrawal of the appeal. They need to take it. I have already given my recommendation for withdrawal of the appeal. They need to take a decision on that.
So, what is the ground you have taken?
Well, initially the ground was taken with regard to the salary of the deceased, but it is not settled principle of law, so I cannot argue with regard to that.
Net salary is 23,000,
Right.
including DA. The court has taken
The salary is was 27,000 plus below. However, after deducting some amount, the net salary as 23,270.
So what's wrong in this?
That's what my lord has already at the outset as subject matter.
Why this has been listed?
My lord, notices is complete, my lord. Both the claimant as also the owner is okay.
Place this case under the heading for admission next week.
Right.
You take decision what you have.
Serial number 9, MA number 265 of 50, Mr. Vijay Kumar Sharma.
Yes, Mr. Sharma, use the microphone, otherwise it is very difficult because of this glass screens.
Instance is by the father and wife of the deceased and
Why it has come under the heading for orders? Ensures there's a right to recovery given. Mr. Ghosh, is there any right to recovery given to you?
Yes.
Where is it?
My lord, internal case number 10, middle paragraph. The deceased was sitting on the roof of the vehicle with two other persons.
No, internal page 10.
CW4 जहाँ लिखा है
No. Tell me from the judgment of the award.
Ma'am,
Any right to recovery given to you?
नहीं, no breach of no breach.
So, this is only for enhancement.
not
What is the ground for your enhancement?
in terms of that message of
10,000.
3,000 euros.
What are the evidence?
And the evidence you will see, the evidence you will see CW2 and they will see stated that they will see.
LCR is here?
You are the farmer, no, yes. LCR.
List this case under the heading for admission. In the meantime, call for the lower court records.
Serial number 10, MA number 358 of 50, Mr. Gautam Kumar, Mr. Sandeep Kumar Banwal, Mr. Gautam Kumar Singh, Mr. Viraj Kumar, Mr. Anil Kumar Singh, for appellant.
Have you filed any application? Yes? Where is the IA? IA,
6643.
use the microphone. 6643. आगे कर दीजिए तो माइक्रोफोन.
6643.
Yes.
That is under order 4127. I have stated in paragraph 6 and 7 of my case. The same list can be represented part of service record.
Yes, what do you have to say?
This was on that very score minus my numbers from Singapore said that all these things has already been dealt by the transport areas judgment. It appears from para 26.
These documents were before the trial court.
Exhibit B is the certificate issued by Mukhya.
Not Mukhya, the railways.
So, but that way the document is considered as that is not been here in the into the
And their children out of the state wedlock also.
No.
The children out of the state wedlock. Then how can you debar those children? What is the finding on that?
Finding of the trial court is on the it appears from para 29 months.
Yes.
On the basis of evidence of record, it has been proved beyond all doubt that marriage of petitioner was performed with the deceased conference by Pharmacia Church Sergeant. So merely on the statement made by the Shamun Hasda and the OP before the special marriage of Sir Arman on the subsequent date that they have been living together as husband and wife since so cannot affect the legality of marriage of the petitioner with Soman Hasda, and therefore OP Barmandia Hasda is not a legally wedded wife of the late Soman Hasda. And on that very basic matter, the finding is at paragraph 33. In the present, therefore, Rodensila Murmu, the legally wedded wife of Soman Hasda, the only son of Rodensila Murmu and Soman Hasda, and both these sons born from Valentina Hasda and Soman Hasda are yet entitled to receive the share in the retirement benefit of Soman Hasda. Petitioner Rodensila Murmu is entitled to receive 1/3 of the property mentioned in the petition. The rest 2/3 is equally divided among the three sons. These are the findings. And so far the amount part is concerned, that is of around 58, that is
The amount is
58, 5 lakhs.
5,81,000.
5 lakhs.
So, her son has also not been granted any
Yes,
relief.
her son has been granted.
Both the ways.
Her son has been granted.
Their dispute relates to the
Why?
compassionate fund and who is compassionate fund and who is family concern.
But in the particulars before the railways, the deceased has shown that this appellant to be the wife. So,
That has also been analyzed and read by the
no, these documents were not before.
It is also undisputed that the
Where is the judgment? Under Order 41/27, the latest judgment. Where is the judgment? On what grounds this application can be allowed? What are the criteria of allowing?
Order 41/27, 1A also.
What is the latest judgment on this point?
And the judgment of
Why do you take these cases for casually? You are moving an application under Order 41/27. You know the limitations. You don't come armed with any other judgments. Don't accept this type of civil briefs, I'm telling you.
Certain.
Confine yourself to bail applications only.
Then certain.
This is not a bail application, Mr. Counsel.
Because due to holiday management could not exist.
I don't know.
I leave it to Lordship. Validity of marriage has been Lordship marriage.
I am not on the validity of marriage. You have filed an application under Order 41, Rule 27. You are not even armed with the latest judgment of the Honorable Supreme Court, which was passed a week back.
It may pass on.
Pass over.
Serial number 11, MI number 362 of 50, Mr. Sabyasachi.
Yes. What is this appeal against? Hearing Act.
Court Hearing Act, Your Lordship, I have asked that by judgment dated 4th of March 2015, Your Lordship, page number 18, Your Lordship, wherein the amount that has been deposited by the Eastern Court Limited, it has been directed at the same date to respondent number 226. Now, in this case, Your Lordship.
So what is your locus standi? How are you agreed by this award? Why do you want to intervene?
Your Lordship, in this case, Your Lordship, we have the petition applicants, Your Lordship, are disturbing our mining operation, Your Lordship. The land has been acquired under Court Hearing Act, Your Lordship. We have deposited the amount.
So this appeal is not an appropriate forum. Where is your intervention application?
Your Lordship, that is 1059 of 2016.
1059 of 2016.
Yes, in this matter, Your Lordship, two of the respondents, Your Lordship, Abdul Soren and Maranamai Emblem, Your Lordship, they have also died, Your Lordship. The substitution petition is to be filed by
So that is not your headache.
that is not my headache, Your Lordship. That is the last order, Your Lordship, that direction was given for them to file a substitution.
I am dismissing your IA. Take down.
Because
IA number?
Your Lordship, they have point out, Your Lordship, paragraph, page number 18, Anisha 1, Your Lordship.
Yes.
The reference, Your Lordship, that was given was at our instance. Paragraph
1059 of 2016.
Only paragraph 1 of the judgment link. May I
Yes.
read, Your Lordship?
Yes.
The two references have been referred under section 14(2) of the Court Hearing Exhibition and the Government Act 1957. The Chief General Manager Rajmahal Group of Mines, a company of Central Government of India, firstly by reference letter number such and such, reference case number 1 of 2006, and secondly by reference letter number such and such, reference case number 5 of 2006 regarding payment of compensation to the proper person as a dispute has arisen with regard to ownership and payment of compensation to the person who is entitled to ownership. Therefore, Your Lordship, this case, reference case has been issued as an instance of the Eastern Court.
Maybe. You are not the appropriate party in this appeal. This IA number 1059 of 2016. This IA has been filed by the Eastern Coalfields Limited, trying to intervene in this appeal preferred by the appellants. Next matter. This appeal has been filed under section 20 of the Coal Bearing Act of 1957 against the judgment passed in reference case number 1/2006 and 5/2006. The reference was at the behest of the Eastern Coalfields Limited, which relates to payment of compensation to proper person as a dispute has arisen regarding ownership and payment of compensation. Thus, to decide who is the actual land user and who has to be compensated, this reference was made. Next slide. The tribunal, after considering the materials on record, ordered that Mahi Soren and Paplu Soren, daughter of late Barajitu Soren, Maramai Hembrong, Talamai Hembrong, Sanjli Hembrong, daughter of late Sursen Hembrong, and late Jitni Lisi Soren are entitled to receive the amount of compensation in respect of the land acquired by the central government for the benefit of Eastern Coalfields Limited. We check from this green flag. Next paragraph. Challenge being dissatisfied with the aforesaid finding, the appellants Babulal Soren and others, Babulal Soren bracket media original and others preferred this appeal. They claim that they are entitled to receive the amount of compensation and not the private respondents. Next paragraph. The council appearing on behalf of the Eastern Coalfield Limited submits that since the reference was made at the instance of the company, coal company, and as the appellants are disturbing the mining activities and are not allowing the Eastern Coalfields Limited to undertake mining activities, they want to intervene and appraise this court about the aforesaid fact, and they want that an appropriate order be passed restraining the appellants and others from interfering in any of the mining activities. Next slide. From the nature of this appeal, I find that the dispute is between the private respondents as to who are entitled to receive the amount of compensation. The tribunal has held that the private respondent are entitled to receive the compensation, which is being challenged by the appellants. Thus, the sole issue in this appeal is to decide as to who are legally entitled to receive the compensation. Next paragraph. Considering the nature of the relief which has been sought for in this appeal and the dispute, nature of relief and the dispute which is in this appeal, this court is, I am of the view that the intervention application filed by Eastern Coalfields Limited is misconceived. Full stop. If anyone, either be the appellant or the respondent, is obstructing mining activity of the Eastern Coalfields Limited, there are other remedies available to the said company. By intervening in this appeal, no useful purpose will be sought, as no relief can be granted to an intervener, especially the relief which is being sought for in this appeal by the intervener. This IA is dismissed as mis.
Serial number B78 of 50, Mr. Alok Lal, and Mr. Santosh Kumar for appellant.
In this case, R4 as guide. Which will stand.
Who is out for? Owner of the vehicle. What is the ground of your appeal? Yes, who is appearing for the claimant? Who is appearing for the claimant in this case? Valid service. There is a limitation application. Yes?
There are 45 days period.
In spite of service of notice to respondent number 1, none appears. Full stop. Next part. IA number 4350/2015 has been filed to condone a delay of 45 days. Full stop. The reasons have been mentioned in paragraph 4 to 8, full stop. 4 to 10, full stop. Considering the said submission, this IA stands allowed. Full stop. Next part, main minute. This case of the for admission after 4 weeks.
Serial number 13, MN number 426 of 50, Mr. Arvind Kumar Lal for appellant, Mr. Vijay Kumar Roy for the respondent.
But in this case, notices also clear so much. So far, no, he is concerned, it has not been properly served because he is not deciding. I think the
Who is 3?
driver of the vehicle.
Driver.
Driver.
So driver is it necessary?
Not necessary, but in both for the party and the
Because respondent number 3 is the driver of the vehicle. Full stop. Considering the status of the respondent number 3, no notice need be issued to respondent number 3. There is this case under the heading for admission. What was the law?
It has already been met.
Oh, it's already been admitted.
He is just a
Serial number 40, MN number 448 of 50, Mr. Mahesh Kumar Mahato, Mr. Asit Baran Mahata for appellant, Mr. Atul Banerjee, Mr. Satish Kumar, Mr. Suman Kumar Bhoj for the respondent.
What is a compromise?
No.
You have filed a compromise petition.
No.
Right?
It has not been regulated on behalf of the respondent.
Then
And it said, party has signed lawsuit, both party has signed.
signed where?
Lawsuit, this is the,
Where? They have signed where?
on the active.
Where is the affidavit? Let's see. So you will file by 2 or 3 days?
No. Both party has signed lawsuit.
I am keeping this on Friday, Thursday. Will you file it by tomorrow, day after tomorrow? It has been submitted that the parties have compromised the dispute. It is also submitted that joint compromise petition will be filed. Considering the said submission, let's discuss next Monday.
Serial number 50, MN number 470 of 50, Mr. Prabhas Kumar Sinha, Mr. Santosh Kumar.
Appellant number 1. IA number 628 of 2022. Yes? You have any objection? This IA has been filed to substitute the deceased appellant number 1, Parameshwar Saw. Full stop. It has been submitted that Parameshwar Saw died on 8/1/2021, leaving behind appellant number 2, his son, and leaving behind appellant number 2 and his son, namely Prakash Kumar. No. Namely?
Santosh.
So what have you written in paragraph 3? Yes? What do you have written in paragraph 3? ऊपर भी लिखे the counsel for the petitioner wants to make necessary correction in paragraph number 3. Leaving behind, allowed, this will be allowed to be corrected during course of the day in reading. Leaving behind Santosh Kumar. So he submits that one of the legal error is already on record as respondent of, as appellant number 2.
I'm having the Aadhaar card of this, sir.
Yes?
It is Prakash Kumar, which is correct. In para 4 I have given Santosh Kumar as well. So I may be permitted to correct para 4.
Right?
यहाँ संतोष कुमार नहीं होगा प्रकाश.
How?
But I am having the Aadhaar card. Yes, for the second place for the from the state. I am having the Aadhaar card there.
File an affidavit. Supplementary affidavit to be filed within 2 weeks.
Or face substitution.
I don't
Serial number 16, MN number 491 of 15, Mr. Alok Lal.
In this case, there are 21 days delay.
Who is appearing? For the respondent. Anyone appearing on behalf of the respondent? Rush notice upon the respondent on present and correct address. Requisites 4 weeks.
Serial number 70, MN number 507 of 50, Mr. Abhay Kumar Mishra, Mr. Abdeep Tushar.
No one is appearing. Copy was served.
They say that we are not appearing. PSRTC, we appear, but now they say that we will calm down. So the Supreme Court has said, now a state of Jharkhand has to appear. That now there is judgment after 2004, the PSRTC and the area which falls within the state of Jharkhand, for that state of Jharkhand has to appear.
Who will appear? Serve a copy upon the state of Jharkhand.
Again, I have to serve a copy to the state of Jharkhand.
Let all the parties be here. Because Mr. Abhay Mishra submits that he will serve a copy upon the state of Jharkhand.
Yes.
First up, prayer allowed. This case after 2 weeks.
Much better.
Serial number 18, MN number 532 of 50.
In this case, on behalf of respondent number 125, I filed Wakalatnama subsequently prior to filing of my Wakalatnama. Mr. Ravi Kumar and
Yes.
his associates Wakalatnama was filed.
Yes, how could you file this?
I seek permission.
How could you file this?
Lord, that is what my Lord, I
Yes,
filed it
tell me. Without no objection?
No.
Without verifying?
That will not.
Without verifying you have filed a Wakalatnama, that means?
That will not happen.
Why you are so negligent, Mr. Hemant Shikarwar? Tell me. If you, with a member of a bar council, acts like this, what would I expect from the other lawyers?
But,
You as a member of the bar council should be extra cautious.
I agree. It's my fault. I should have.
Mr. Hemant Shikarwar begs apology and submits that due to inadvertence, he has filed the Wakalatnama on behalf of the
Respondent number
respondent number
125.
1 to 5. He submits that he couldn't verify the fact that respondent number 1 to 5 had already appeared through another set of lawyers. He submits that the Wakalatnama filed by him and his associates be ignored and he may be permitted to withdraw the same. First up, considering the apologies which is being sought for, allow the Mr. Hemant Shikarwar and his associates to withdraw the Wakalatnama. Let the name of Hemant Shikarwar and others be deleted from the cause list. Yes, what is this?
This is appealed by the insurance company.
On what ground?
But two grounds. One, your lordship, they have produced a driving license to show that it was being driven by a lordship duly.
He was driven by lordship.
No.
Then why do you use these lordships in every third word? Please stop this.
It was being driven by a properly licensed driver. So we laid an evidence. We made an inquiry in the RTO office. RTO office gave it in writing that no, this extension of license and this license has not been issued by our office. Endorsement was from RTO Bardhaman. We got it verified that reports were exhibited at Exhibit A and Exhibit B But that has been discarded by the learned court only on the ground that no officer from the RTO office has been examined. Our evidence was led. The officer who had gone and verified also he has given.
Yes, who is for the owner? Owner. What reply? The documents it is already on record. So, have you rebutted that same? Now the second question is whether the Evidence Act is strictly applicable in this motor vehicle cases.
Large number of judgments which says Evidence Act is not strictly applicable while holding the favor judgments. Even in the motors of negligence, the Honorable Supreme Court said that even the charge sheet file is sufficient because Evidence Act is not applicable.
Sufficient for what purpose?
For determining the negligence on the part of.
Show me that.
Those judgments will be used. Here in this case, report to obtain officially proved by the officer that yes, I had gone, I had made an application. But the cross-examination is to the extent that whether the report was prepared in your presence. He said no, it was not prepared, but it was handed over to me by the officer.
This case under the heading for admission. No, he has disputed the driving license at the very initial stage. Then? You have satisfied the amount? Satisfied the amount? You get it?
One more thing on quantum also, we have challenged partly on quantum also.
What is the quantum? What is the challenge?
Also the challenge is, you should take into consideration, the penal interest has been awarded, 9% interest was awarded and it is stated if not paid within 30 days, then 12% interest. But that has been the Honorable Supreme Court has said also that in case.
That is
one part, and second part is also taken into consideration. Maximum will deposit the award before the registered of the principal amount along with 9%.
Because in the meantime, the insurance company will deposit the amount of compensation along with 9% interest before the Registrar General of the High Court of Jharkhand at Ranchi. Full stop. Next para. If the amount is deposited, it will be open to the claimants to file an application. It will be open to the claimants to file an application praying for withdrawal of the amount.
Serial number 19, MA number 533 of 50, Mr. Vijay Kumar Sharma.
I am appealing on behalf of respondent.
Respondent number 1, you have not filed.
Yes.
You have not filed requisites.
22 issued notice to respondent number 1 within 3 weeks.
You have not taken steps. The appellant has not taken steps pursuant to the order dated 22/2022. Full stop. What do you want?
2 weeks.
Full stop. On request of the learned counsel, 2 weeks further time is granted to comply the aforesaid order by filing necessary requisites.
Serial number 20, MA number 3 of 70, Mr. Alok Lal for appellant, Mr. Devan Shah for the respondent.
Yes. Are you for?
In this case, R4 has died.
Who has died?
R4.
Who is R4?
last question on those parts. Your lawsuit was reached directly run to and then Rekha Devi and Rekha Devi and
They are already on record.
no. ये Khamral Saab had and the years of the Khamral Saab with your record. But
We have not filed.
After 2 weeks, and
On the request of the learned counsel for the appellate, this case is adjourned for 2 weeks.
Possible matter, the heading for order, serial number 10, MA number 358 of 50.
Mr. Abhi, no one was there.
No, it's the appeal matters. He was asked to give the judgment here.
Under the heading for admission, serial number 21, MA number 142 of 50, Mr. Vijay Kumar Sharma.
Have you filed Vakalatnama on behalf of the insurance company? Have you filed Vakalatnama? This is for enhancement. On what ground?
Maluk state regulators and regulatory candidates. It's like to not, but I need that. We work with the candidates.
Is he the competent authority or the court to grant you time? So you take this court very lightly. So you both decide and you don't read the file. He tells you that he will seek an adjournment and you take it for granted that the court will adjourn this matter. Argue. What is your ground for enhancement?
I need that.
Very good. Mr. Santosh Kumar appears on behalf of the insurance company and prays for some time. First up. Next paragraph. The counsel appearing on behalf of the claimant also prays for time. First up. This appeal is by the next paragraph. By the claimants praying for enhancement of the amount of compensation awarded under section 166 of the Motor Vehicle Act. LCR is here. Next one. The appeal which could have easily been disposed of today is being lingered at the instance of the lawyers. Since both the lawyers prays for time, and then this court court is not in a position to decide this matter. As there is no assistance from the lawyers. This case is adjourned for 4 months. Let a copy of this order be communicated to the claimants and the insurance company.
Serial number 22 with serial number 23, MA number 182 of 50 with MA number 331 of 60, Mr. Kisija for appellate in first case, Mr. Rajiv Ranjan, Mr. Ashutosh Anand, Ms. Ruby Pandey, Mr. Prashant Kumar Srivastava for appellate in second case.
Yes.
There are two.
One is for enhancement and one is for.
Our is the calculation made by the calculator. Calculator has not deducted any. As per the judgment it should have been deducted 1/4. But the judgment has not deducted, simply calculated and provided the amount deduction. And for conventional head, it has been awarded 1,75,000. That may kindly be seen in.
Now, what is the income?
Yes.
32,966.
Yes, 32,966. That includes the allowance, food allowance, washing allowance, extremist allowance, and miscellaneous allowance also. These are all.
Now, it is the gross minus the income tax. Now, the gross income less the income tax.
Less the income tax. But you also in some judgments, you also it has been.
Forget about the earlier judgments, come to the latest judgments.
It has been hand you also with the reimbursement. Reimbursement, here the medical allowance also is there. Medical allowances का voucher दिखाया जाता है, कभी वो reimburse होता है. So these allowances you are also fixed. Washing allowance, that is in paragraph. It is there in paragraph. The allowances include food allowance.
The court has considered monthly income of the deceased to be how much?
Court has considered monthly income of the deceased comes to 19,940 being the basic salary.
28.
28,913. 28,913.
So there is yes. Then
and then
multiplied by 12.
Multiplied by 12, Your Lordship, and
then
no deduction. It is mentioned in next page. 45,95,690. Thereafter, in next page, you have admitted deceased of 42 years of age. The deceased will further entitled for enhancement of 30%. Correctly it has been given. Therefore, the total amount particularly lost to be claimant would be 45,95,690 plus 30%. That comes to 59,74,300
plus 30%.
30%. He was 42 years. Even as the price of
30%.
that is correct.
So it comes to
59,74,332.
So there should be a deduction.
Yes,
for personal how many claimants?
So there are four numbers of claimants. 1/4 should be.
So 1/4. 1/4 has to be deducted.
Yes. In conventional head, 1,75,000 has been.
Yes, Mr. Counsel.
Your Lordship, on last date we had decided, we were decided, Your Lordship, that the salary was 32,966 on the basis of allowances. I had just given a document to the certificate also. So, Your Lordship, the calculation, Your Lordship had given the direction to the respondents to consider the quantum of 86 lakh rupees. And
No. What do you say about these deductions?
Your Lordship,
It should be 1/4. Deduction should be there.
yes.
And this 1,75,000 is also much more.
Yes, sir. For loss of guardianship, since there were 3 children, because we are getting 1,50,000 for loss of guardianship. 1 lakh is consortium.
Can that be in view of the Pranay Shetty's judgment?
Yes. 70.
So what it should be? 75,000?
Options for consortium or?
Yes, for consortium and your funeral expenses and all these conventional head.
So for the loss of gratitude, it also be using the big minus.
Show me the judgment. What is the latest judgment on this issue?
Last week, maybe something maybe that now. Someone that I have for the allowances to be.
Allowances to be no, will come one by one.
Yes.
Now tell me what about the deduction? You also admit that 1/4 should be deducted.
Yes.
Now what about the conventional head? What are the judgments on the conventional head by the Honorable Supreme Court?
Number 59.8, that is reasonable figures on conventional debt, namely loss of estate, loss of consortium, funeral expenses should be 15,000, rupees 40,000 and 15,000 respectively. That is total 70.
That is 75,000. 70,000. Pranay Shetty.
And on 13/1/17, Your Lordship, for grant of estate, we have deposited 20 lakhs and it has been disbursed. And Your Lordship, in this case, 9% interest has been awarded, failing this 12%. These are our grounds, Your Lordship. Your Lordship, I have the name of the judgment, I don't have the judgment.
Yes.
Your Lordship, according to the Rajesh case, loss of consortium at 1 lakh and Santosh Devi case.
So Rajesh is not a binding precedent. In view of 59(2). So the main contention, the bone of contention is the salary. What should be the salary? What are the evidence which you have? Yes. What is the evidence? Payslips, exhibit.
Exhibit 3 to 3 by 2 is a payslip erosion. Exhibit 4 to 4 by 1 is a that is 3 to 3 by 2.
It's 32,966.
Yes.
$32,996 is the salary.
Yes. And the gross salary.
So what will be the income tax?
24,000.
Into 12. What's 3 lakh 95 952.
395, 590.
3 lakh 95.
590.
952. What was the standard deduction at that point of time?
1,60,000.
No.
What if we find a supplementary that bringing up without income tax?
This is 2011. You have filed a supplementary affidavit. Where is that? When did you file it? 6/12.
Yes.
Why is it not on record?
Sorry, 29.
29?
29.
29. What is the supplementary affidavit?
It is the income tax slab.
Show me. Bring it. Call for that. Standard deduction was 50,000 at that point of time.
I have consulted one CA evaluation as per his calculation evaluation and rating. He has informed me that 1,60,000 was his limit. So 10%.
1,60,000 was the
160 to 5 lakhs.
160 to
No, up to 160 there was no.
Mr. Counsel. Up to 160 the tax rate was 0.
Yes.
But out of this total income, the standard deduction 80C has to be deducted, then only the taxable income will come.
So he has made a calculation.
No.
He has
How will you know that upon which amount what tax one has to pay? So this is the gross income. Now out of this amount, the standard deduction, 80cc, everything all has to be deducted. So there is nothing, 80C deduction is not on record. So standard deduction was how much? 50,000. So from this 50,000, if it is 50,000, from this 3,95,000, 50,000 has to be deducted. So then it will be 3,45,000. So out of 3,45,000 less 1,60,000 is how much? That will be the slab, then the slab. Let us see 1011. What is the standard deduction?
just 10% from 160,000?
It's not that. It's not flat. Anyone can help?
That is the add-on. I will again consult, because as per my consultation, Your Lordship, 1,60,000 to 5,00,000, 10% per year.
That 1,60,000
To 5,00,000.
to
5
no,
lakhs.
to 5 lakhs.
It was 10%, Your Lordship. And in the year, financial year 2010-11, Your Lordship.
No, he has given this 10-11. He has given this chart. Calculate.
Yes.
It is
And
up 1,60,000. It is nil till 1,60,000. From 1,60,000 to 3 lakhs, it is 10% of the amount exceeding 1,60,000. And from 3 lakhs to 5 lakhs, it will be 14,000 plus 20% of the amount exceeding 3 lakhs.
3% sales were also there. So 706
No.
sales.
So there is a standard deduction or component also there in 2011 too. After the standard deduction, then only this table will come in effect. What it was 25,000, 30,000. What was the amount?
As per that calculation, to which as arrived by the CA, that is 24,265.
It can't be. 24,000?
24,265.
This is income tax. I don't think so.
फिर हम लोग इसको वेरीफाई कर लेते हैं.
Just a minute. Why waste time? I'm just passing it over. Assessment here 10-11 में standard deduction करना है. ठीक. तुरंत पता लगेगा. Accounts establishment. Assessment here. Just pass over it. I'm directing my office to inform what is the amount of standard deduction at that point of time. Yes, next case.
Serial number 24, MN number 21050, Mr. DC Ghosh.
Yes, Mr. Ghosh.
Para
18.
The deceased was of age of 30 years, doing calculation business, income 3,000 per month, 80. Last one. This future prospect should be 40%. Then we will space. 19. This calculation 10,000 and 1 lakh. This would be 7.
As per you, what will be the amount?
This future prospect should be 40%.
Future prospect should be 40%.
And instead of granting 1,10,000, standard award should be 70,000 towards.
That means 30,000 on this side. 30,000 or 40,000.
40.
40,000 and 10% will be how much? What will be the total amount involved?
Instead of 4,500, this would be
4,200 into 12 into 17.
17 minus
1/3 has already been deducted.
1. They are after
5,71,000. Over here it is 6,12,000.
It comes to
No, 6,12,000
7,22,000.
plus 70.
Total given
6,41,000. 6,41,000. As per you, Mr. Ghosh. And now it is 7,22,000.
See. Multiplied by 17 and
80,000. What is the income is 3,000.
3,000 taken
Why notional?
as no documentary evidence to support the contention of the disease was doing business.
No, what is the claim he was? LCR.
Subsequently, wife has been
Remarried. That is.
working in the house of the secretary.
Now who is claiming? It is the mother and father.
Yes.
You are for the mother and father. Huh?
This person.
It's only about 3%. Yes, it's malnutrition. Last time, there was someone made work appeal last time.
What was the deceased to? How was he earning his livelihood?
Doing business is what is
Yes. Yes, he is saying that you have been paid 80,000 more.
Memo appeal the next date में appeal please get the process memo appeal from the government process memo appeal को ले लिया है
You serving a memo of appeal. With the council opinion on behalf of the appellant claimants and the respondent claimant submit that he has not received the memo of appeal. He prays for some time and prays that the appellant may be directed to serve a memo of appeal upon him. Considering his submission, this case is adjourned for 1 week only. Instead of the memo of appeal should be furnished upon him. In the meantime, call for the lower court records.
NCR से इसका नंबर नहीं है, pilot wants to dispose of, can you accept it?
Huh?
अगर if pilot wants to dispose it of,
No. I want to see what is the evidence of the income.
then it will be still after 2.
After 2 weeks. After 2 weeks. If there is some evidence about income and the difference is only 80,000,
Certainly.
they have to meet that also.
Yes.
Serial number 25 with serial number 26. MA number 474 of 50 with cross objection. 21 of 21. Mr. Alokal for appellant first case. Mr. Vijay Kumar for appellant in second case.
On the ground of Advocate Alok Lal, prayer has been made to adjourn this case. This case is adjourned 2 weeks.
Serial number 27 with serial number 28. MA number 108 of 60 with MA number 257 of 60. Mr. Manoj Kumar Shah for appellant in first case. Mr. G. Sija for appellant in second case.
Yes, where is Mr. Manoj Shah? Pradeep Kumar Verma and Arun Kumar. Right? Yes? Who is the arguing counsel? Yes? Yes? I don't know. I don't know. This is not a ground. You will have an extended holiday and you will say that the lawyer has not reached. This is not a ground. No? Yes, Mr. Jha. You are. Let me decide. What is the ground?
Date of accident is 9/2/2012. Deceased was Devi Kumari, 34 years. She was coming from she was boarded in a motorcycle and she was hit by a tractor in her. The tractor having no registration number in her, and the tractor was being tried without any registration number. There was no registration.
There is two things. The tractor was plying without displaying the registration number is something.
Yes.
And that a tractor was plying without being registered is two different aspects. Without it being registered. So what is your case? The vehicle was being plied without affixing the registration number, or it was not at all registered?
It was not at all.
Then what is the what about the insurance?
Yeah. Insurance was done on the basis of engine number and registration.
And then the same tractor was met with an accident?
Same tractor.
So
I have inquired this matter because this matter was came before the workshop earlier also, and this question was raised. I have asked this question, particular this question, to underwriting departments of different insurance companies. It has been
informed us that the general practice of the DG office before issuing any registration, either temporary or permanent, they are insisting upon the persons to come along with the insurance policy on the basis of injured and registered. And on that basis, we are providing the insurance policy. Thereafter, they usually go before the registering authority, and within a separate period of 10 days, 15 days or some registration has been allotted to him. Here in this case, he has not came before any registering authority, इंश्योरेंस करा लिए, उसके बाद गाड़ी चला रहे हैं, एक्सीडेंट कर दिए, और जिस दिन एक्सीडेंट किए उस दिन ही टैक्स जमा किए, टैक्स तो नहीं जमा किए, टैक्स भी उसी दिन जमा कर रहे हैं, और उसी दिन ड्रॉपशिप एंड रजिस्ट्रेशन का हुआ भी नहीं. This is the position. We have specifically inquired this gentleman. He, long before 4 months back, insurance policy was given to you on the basis of engine and chassis. Because engine and chassis number अगर हम नहीं देंगे, तो again it will be misused. So at least identification के लिए हम लोग के पास उतना ही चीज रहता है. And this is the practice in entire Jharkhand and in Bihar election. Only after obtaining the insurance policy, the registration number is given, either registered temporary or permanent. It has not been given in this case. They have not even applied for it. And there are 3 judgments of the Honorable Supreme Court that if the plaintiff is being applied without registration number, insurance company has been held not responsible for any payment. Those judgments are given. Yes.
You are on behalf of owner.
I am only reading that particular.
No, give me the reference.
That is 2014 9 SCC 324 regard. Judgment of Justice America and PC position. Using a motor vehicle on public road without registration is not only an offence punishable under section 192 of Motor Vehicle Act 1988, but also fundamental breach of terms and conditions of the policy contract. Contention that purpose of temporary. Well, in this case, there are another 2 judgments also, Your Worship. One of 2021 and another is of 2020.
Give me all the reference.
Yes. That is 2021 SCC online. SC 844.
344.
844.
844. Pass the judgment. Copy of the judgment.
And one more judgment is there also 2020.
Give me 2021.
And in all cases, there was a temporary registration. It expired, and they have not renewed or has gone for the permanent registration or for extension of the temporary registration.
So it is a breach of condition. So if there is a breach of condition, why not pay and recover?
This is
Yes. Then it was insured. It was insured, but you were driving without the vehicle being registered. No one is doubting that. No one is doubting that. You give me the registration number of the vehicle and the date when the vehicle was registered. Fine. Why should we fight? This is an appeal, Mr. Counsel. You are the insurer of the tractor. It was a composite negligence. And the tractor was only made a party. Where is your plea that the vehicle was not registered? Where is your plea that the vehicle was not at all registered?
Yes, in para 8 of our written statement, the offending vehicle tractor was unnumbered, and according to FIR of the case, there was no any registration number, and the tractor was flying on the road without registration number. Claimant himself stated in para 8 of the claim application and FIR of the case. Therefore, owner is responsible and liable for violated the provisions of MD Act, so that the OP insurance company should not be liable in this case. It is submitted that according to section 39 of the MD Act 1988, no person shall drive any vehicle in any public place unless vehicle is registered in accordance with the same position which the Honorable Supreme Court has in Europe. That point already taken.
Where is your written statement? Where is your written statement? The chair is here. What is your written statement? OB number?
I have OP number 3, Oriental Insurance Company.
You have not filed any written statement. Then you have not laid also evidence. What is the document of the vehicle? Documents of the vehicle is on record. Is it on record, the documents of the vehicle, offending vehicle, the tractor? Where is the registration certificate of the tractor? Yes? The insurance company has taken a plea that the offending tractor bearing engine number NGNL-1737 and chassis number NGNL-1737 was not registered at the time of the accident. It is submitted that the tractor was only insured by mentioning the chassis number and the engine number. He submits that in view of the judgment of the Honorable Supreme Court in the case of so-and-so versus so-and-so as reported in 2014, Volume 9 SCC 324 and 2021 SCC Online SC 844, no vehicle can be plied on the road without a registration, without being registered. It submits that the aforesaid violation is a fundamental breach of the condition of policy as held in the aforesaid two judgments. First up, he submits that the tribunal framed an issue as in respect of violation of the terms and condition, but ignored the aforesaid aspect, though the same has been specifically pleaded in paragraph 8 of the written statement of the insurance company. It is also submitted that no specific issue, he submits that specific issues about registration of the vehicle should have been framed, which the tribunal failed to do. Full stop. Next paragraph. The counsel appearing on behalf of the owner of the vehicle, offending tractor, submits that the owner neither appeared before the tribunal nor filed any written statement or nor led any evidence. Next paragraph. Considering the submission of the parties and the plea raised by the insurance company that there should have been that the insurance company should have been given a right to recover the amount from the owner of the vehicle, since there is a fundamental breach of the policy, an additional issue needs to be framed. Full stop. Needs to be framed as follows. Full stop. Whether the tractor in question bearing engine number so and so and chassis number so and so was duly registered with the transport authority on the date of accident, date and time of accident. If yes, then what is the registration number? Yes, Mr. Jha? What is the registration number? Full stop. This additional, without deciding the aforesaid additional issues, the plea of the insurance company claiming right to recover cannot be adjudicated properly. Full stop. Thus, the aforesaid issue, after framing the additional issue, I direct the Motor Accidents Claim Tribunal to record its finding after taking evidence on the aforesaid issue and remit the same to this court within 4 months. Full stop. Next para, the insurance company and the owner has appeared before this court, who will cooperate before the tribunal. Full stop. They will appear before the tribunal on, you appear before the tribunal on or before 5th of April, on or before 5th of April, by filing respective wakalatnama. Full stop. It is made clear that the insurance company will prove and bring on record the registration certificate.
Registration certificate?
Yes, that will prove when it was registered. I will not allow him to file his pleadings. Registration certificate of the offending vehicle, which will substantially prove the issue.
If not,
I don't think he will fail.
at the time of accident, when there was nothing on the
No, when it was, Mr. Counsel, the date of registration, first registration will prove that when it was registered.
after.
Yes.
After.
If it is before accident, then it is something else. It is made clear that no the insurance company will bring on record the registration certificate of the vehicle, or any evidence to prove that the vehicle was registered after the date of the accident.
Same thing should also be said.
He has not filed any pleadings. The owner of the vehicle is free to produce document and lead evidence only if he claims, if it is his claim that the vehicle was duly registered at the time of accident. Let the finding be clear. Let the LCR be sent to the court below through special messenger. This appeal is kept pending. The judgments. List, list. LCR may be used. No, LCR. Yes, next.
Serial number 29, MA number 174 of 60, Mr. DC Jha.
In this case, bring for only one way.
Right. What is your prayer in this?
I couldn't go to the fight because today morning I have written outside the house. Day after tomorrow,
Contributory negligence. On the request of Mr. G.C. Jha, let this case be listed day after tomorrow.
One thing, because we have prepared this appeal and we gave it as a clear logic. In most of the cases we have seen that if they have filed any announcement, that should be dealt with this case.
You have filed an announcement? There is no announcement.
It should be made clear. In many cases, we have seen that one case is being disposed of and another case is being treated. So,
let us see, we will see. Yes. Wednesday.
Serial number 30, MN number 290 of 60.
It is only on the point of interest. Yes.
There are four dependents, but the four people has deducted only one. It will be one.
Who is the deceased?
The deceased is wife, son, wife, mother, father.
No. What is the deceased? What is the name of the deceased?
Name of the deceased is Prakash. Prakash. He was aged. He was
Prakash Rao died. 2 and 3 are the mother and father.
Yes. Mother, father, wife, and son. The gift.
So there are 4 heirs. So it should be 1/4. And your interest. So far as your income is concerned, you have no grievance.
No.
No grievance. Income multiplier age, no grievance.
No future prospects has been granted.
Future prospect has also not been granted.
Future prospects.
Mr. Bosch?
My lord, regarding first and second outcome, regarding future prospects, on the record there is, it is apparent that neither there is pleading nor anything.
No, future prospect need not be pleaded. This, while computing, it is the duty of the court.
Yes.
There is no necessity of pleading about future prospects. The court has to see just compensation, fair compensation. So this is a component of just and fair compensation, future prospect. So, but what about his 1/4 reduction is 1/3, and interest? What do you have to say? Let me see the LCR. LCR is there? Case is of the year 2013, disposed of in 2016. So it's only 3 years.
Rate should be or maybe whatever minus maybe
7%. Only. Third, the counsel appearing on behalf of the appellant and heard Mr. D.C. Ghosh appearing on behalf of the insurance company. First up, this appeal is at the behest of the claimants. Claimants of compensation case number 37 of 2013, which was disposed of by the District Judge 2, Presiding Officer, Motor Accidents Claim Tribunal, Lohardaga, by the judgment and award dated 11/3/2016. Next paragraph. The counsel appearing on behalf of the appellant submits that the tribunal, while awarding compensation, has incorrectly assessed the dependency and deducted 1/3, whereas the tribunal should have deducted 1/4, as admittedly there are 4 dependents of the deceased. He further submits that the claimants are entitled to enhancement of compensation on account of future prospect which has not been considered. He further submits that only 50,000 has been granted on account of under conventional head, whereas in terms of the judgment of Pranay Shetty and others, an amount of rupees 70,000 is paid. 70,000 is paid. He lastly submits that no interest has been awarded. No interest has been awarded in favor of the claimants, and no reasons have been assigned for not awarding any interest. Also, next paragraph. Mr. D.C. Ghosh, appearing on behalf of the insurance company, submits that yes, please submit.
On the issue of the Darshan blood, I have no objection. Interest is up to the court.
He submits that the Honorable Supreme Court, in the case of Pranay Shetty and others, have adjudicated all the issues and has now decided our claim application has to be decided. He submits that this court has to follow the aforesaid judgments. Next paragraph. So far as the point of interest is concerned, he submits that there is nothing on record as to why the interest was not granted. Have you satisfied the award?
Yes, certainly. Yes.
He submits that since the award has already been satisfied, no interest is liable to be paid to the claimants. Next slide. Considering the very narrow scope of this appeal, this court feels that this appeal can be disposed of at this stage itself. Next slide. There is no dispute in respect of the income, age of the deceased, the nature of accidents and the nature and manner of the accident, and the fact that the vehicle was duly insured with, the offending vehicle was duly insured with National Insurance Company Limited. There is no dispute that there is no violation of the terms and condition of policy. The only dispute is in respect of the quantum, that too, in respect of the dependency, future prospect, and the interest, and the quantum of interest. Next paragraph. After going through the award and judgment and award, I find that the age of the deceased was just above 25 years. The tribunal has considered the income of the deceased to be 7,150 per month. This quantification has not been disputed by any parties. From the record, I find that there are 4 dependents. That is the father, that is the father and mother of the deceased, and the wife and a minor child. Thus, since there are 4 dependents, 1/4 should have been deducted on account of dependency. Full stop. The court has deducted 1/3, which is not proper. Full stop. Further, I find that no enhancement on account of future prospect has been awarded by the tribunal. Full stop. In terms of the judgment of the Honorable Supreme Court in the case of Pranay Shetty and others, the claimant, who is aged about 25 years or more, just above 25 years, and was self-employed, as well as a self-employed, is entitled for an enhancement of 40%. Next. Under the conventional head, I find that 50,000 rupees has been awarded to the claimants, whereas in the case of Pranay Shetty and others, Supra, the Honorable Supreme Court has held that the deceased, the claimants, are entitled to an amount of rupees 70,000. So thus, in this case also, the claimants are entitled to an amount of rupees 70,000 and not 50,000 as awarded under the conventional head. Full stop. Next one. So far as interest is concerned, I find that no interest has been awarded to the claimants. First up. Section 171 of the Motor Vehicle Act of 1988 provides for grant of interest. First up. The provision of the law is quoted as below. Quote kar dijiye. From the aforesaid provision, it is quite clear that the tribunal may direct that in addition to the amount of compensation, interest at the rate so fixed by the tribunal can be paid to the claimants, but from such date which should not be earlier from the date of making the claim application. Thus, the provision to grant interest is there in the statute itself. And a claim application under section 166 of the Motor Vehicle Act is a claim for compensation, and in true sense it can be said to be a money claim against the insurance company or the owner of the vehicle arising out of an accident. When a money claim is being made and is allowed, it is but natural interest has to be granted. First off, judgment dijiye. Motor accidents claim tribunal, railway accidents tribunal interest or judgment dijiye. The amount of money which a claimant is entitled to receive is utilized by the person or the institution who is supposed to pay, then the aforesaid institution must compensate the victim by paying interest. First off. Denial of such interest should be specific and must be followed by reasons. Normally in a money claim, as I said earlier, interest should be the norm. First off. Only when the same is denied, the same can be only when we cut it. And when the same is denied specifically, the same has to be by way of reason. First off. In this case, I find that no interest has been granted in favor of the claimants. Further, no reason has also been assigned. दोनों का बीच में लिख दीजिए The Honorable Supreme Court in the case of so-and-so versus so-and-so, 2009-7-372, while dealing with a claim under the Railways Act of 1989, has held that normally when a money degree is passed, it held in paragraph 26 as under 26 code, 27 code. Let's talk about reasons for it. Thus, this court holds that the claimant is entitled for interest. Now the question is, from when the claimants are entitled to receive the same interest? First up, Section 171 clearly provides that the interest should be granted from the date of filing the application and not a date which is earlier in time. In this case, I find that this claim case was filed in 2013, which was disposed of in 2016 itself, March 2016 itself, which is full stop. The time thus consumed is less than 2.5 years. It's much less than 2.5 years. Full stop. Thus, it can't be said that there was delay on part of the claimants, or the claimant has lingered the proceeding. Thus, in my view, thus I hold that the claimants are entitled to claimants are entitled for an interest to the tune of ₹7% per annum, simple interest, the rate of 7% per annum, from the date of filing of their claim application full stop. Next one. It has been submitted that the award has been satisfied. Full stop. Thus, the Motor Accidents Claim Tribunal will recalculate the amount of compensation considering the findings made above, and the insurance company is directed to pay the balance amount within 12 weeks. Within 12 weeks. With the opposite observation, this claim application is allowed to the aforesaid extent, only to the aforesaid extent. Or just let me recalculate it. हम कर दिए थे तो 40% future prospect. We get a future prospect is 40%.
और सर कुछ अमाउंट इस पर जाएगा 70,000 to 60,000.
Yes, 20,000 first मैंने लिखा. Now एक काम कीजिए, करिए last part करिए. Thus, if the amount of compensation is recalculated, the same will be as follows. लिखिए 7150 less 1/4 into 12 into 17 equals to so and so. Add 40% equals to so and so. Add 70,000. So and so is the just and fair compensation which the claimants are entitled to receive. Full stop. The tribunal has awarded 10,22,468. No, sorry. Yes, 10,22,468. Thus the balance amount will be so and so. Okay. Interest at the rate of 7% per annum on 10,22,468 from the date of filing till the payment, and 7% per annum from on the balance of so and so from date of filing till the same is paid. आपको to calculate वाला करना है. This appeal stands about. The amount should be paid within 12 weeks.
16 per day.
No, too much. Next.
Serial number 31 with serial number 32. MA number 377 of 16. Cross objection 34 of 21. Mr. Vibhas Sinha for appellant in first case. Ms. Rakhi Rani for appellant in second case.
There is a free and the cross objection by the jurors.
Yes.
For evidence.
Have you satisfied the award?
Yes. Here for 2 lakhs we have already paid and also to the court's order, the remaining amount was just provided a copy of the check that is deposited.
You have deposited.
Yes. But now the difficulty is they have not substituted the deceased person because 2 of the persons.
Who has died?
In this appeal, the name has already been deleted. In this appeal, due to state lordship, in the executing court, the name of one claimant could not be deleted. We have filed now.
We have deposited the check the moment they will delete their they will be validated.
Deleted.
Yes, we can delete the
PO is on deleted. We have filed application.
He is not live for another eternity. Then which PO?
On the running code PO.
Mother and grandmother is also right. Now the only we have sons.
We have already deleted the name of those claimants have already been deleted in this appeal.
In this appeal, they are saying that before the tribunal, if you don't delete them,
That's true.
then you will not get the fruit of this degree.
Yes.
The check will be in the name of dead person, right? Most probably the PO has joined. The presiding officer has joined, most probably.
Let's make this book of this appeal.
No, then
Now there is one matter.
what is the issue?
2 things. First of all, their cross objection is there.
First argue your opinion. What is your point?
But I have filed this appeal on 3 points. Number 1, the FIR which is charged to exhibit 1 that shows that as per the FIR, Pablo Mandal was guardian. However, my lords, from NCR, it also appears that the police, after investigation, exonerated that Pablo Mandal and submitted charge sheet against the Yugal Prashad Mandal, showing Yugal Prashad Mandal driving the offending tanker at that time. So, one defense we have raised before the court below also and before this aspect of law, that is a case of interpolation by the police itself because the deceased was the police constable. The fact of the case is that police constable who was the deceased, his name is Vijay Bhushan. He found a parked unclaimed motorcycle. He along with his friend taken that motorcycle to be placed to the police station. Meanwhile, when they reached near some chowk, one offending truck which was tanker that has dashed him. On the spot, FIR is very clear. The people have apprehended the person who was trying to be.
He was apprehended.
Yes, he was apprehended on the spot.
Then?
And he has disclosed his name probably. He was taken into custody. The police investigated, but when charge sheet was submitted, the IU has said that Pablo Mandal was not the culprit, the actual culprit was Yugal.
If he was taken in custody, how was he released?
Definitely he must be released because
Without bail he couldn't have been released? Or police bail if it is
subsequently this Yugal Prashad Mandal is patient trial because he was charged.
Sorry, what you are trying to project is correct, then this is a very serious issue. The Honorable Supreme Court is in session of a case where The failed claims are the
charge sheet is of Margaret Smith's charge sheet will be the same. The FIR is very specific. टैंकर चालक द्वारा टैंकर भगाने के क्रम में स्थानीय लोगों के सहयोग से टैंकर चालक को पकड़ा तथा उसने अपना नाम बबलू मंडल, पिता आनंद मंडल, साखी सचिन सच हंसा जिला बताया। चालक बबलू मंडल बताया कि तेल डिपो से डीजल लेके रतनपुर जा रहे थे। टैंकर का मालिक सचिन सच है, मेरा दावा है। He was apprehended.
Who is the owner?
Taken into the custody.
Yes? Is Jugal Prasad Mandal and Bablu Mandal the same person?
Because in charge sheet it is mentioned, there is no evidence against Bablu Mandal. He is being exonerated.
So when a person is apprehended from the spot, how does his identity changes if he is not the same person? A person can be named as Bablu Mandal alias Jugal Kishore Mandal. Is it your case that Bablu Mandal and Jugal Kishore Mandal are the same person? So you will be knowing who is driving. If it is Bablu Mandal who is driving and if he did not have any license and just a person has been implanted of? No, Bablu was arrested from the spot as the driver.
Bablu was arrested from the spot. He was taken into custody, granted bail.
By the court?
Yes, by the court. That is a case very that is what has been made. Here it is mentioned. मैं घटना के समय पकड़े गए।
The main plea which has been taken by the insurance company is that the driver who was driving the vehicle has been let off and some other person has been transposed as a driver, which is evident from the FIR and charge sheet itself. He submits that when the accident had occurred, the police and others chased the vehicle and apprehended Bablu Mandal, who was driving the vehicle. Full stop. The same Bablu Mandal was taken in custody and was produced before the court, and he was granted bail by the court. But surprisingly, when the charge sheet was filed, this Bablu Mandal was exonerated and some unknown Jugal Prasad Mandal, another person, Jugal Prasad Mandal, was shown to be the driver of the vehicle. Mr. Vivasena, appearing on behalf of the insurance company, next line, submits that there is nothing on record to suggest that this Bablu Mandal and Jugal Prasad Mandal are the same person. He further submits that this suggests that Bablu Mandal was driving the vehicle and was not having the proper authority to drive the same, and only to save the owner of the vehicle. Later on, during investigation, a person named Jugal Kishore Mandal, who was having a valid driving license, was shown to be the driver. Next paragraph. You appeared before the court below? What was yours? What is your stand? If the aforesaid submission of the learned counsel appearing on behalf of the next line next paragraph is the counsel appearing on behalf of the insurance company is correct, then this is a very serious issue. Full stop. Thus, What is the case number? What is the GR case number? Which court? Thus, I direct the Principal District Judge Dhanbad to immediately send the entire original record of GR number 1670 of 2015 arising out of Dhanbad within bracket Bank Code PS case number 362 of 2015. Entire original record through special messenger. This case after 2 weeks. If I find something wrong, I will direct an inquiry by a special investigating team.
But this is a fit case because the deceased was to his hospital. The person who was apprehended on the spot admittedly as per FIR was Khalasi. He disclosed I am Khalasi driver where Angadi chala hai. FIR is there. But the charge sheet comes, he was person with another person because now the insurance company has to pay. They will never receive 51 lakh from the owner.
What is your business? Now what do you have? How many tankers you have? In the meantime, the owner of the vehicle is directed to file an affidavit before this court mentioning the number of vehicles which he have in his fleet. Nature of vehicles and the number of vehicles which he has in his fleet, as it has been submitted that he is a tanker owner. It is made clear that he will not transfer any of the vehicle in favor of any person. Yes, yes. After 2 weeks on a physical date.
Serial number 33, MA number 499 of 16, Mr. Chandranjeet Mukherjee.
I was praying for a short passover here. My senior Mr.
Chandranjeet Mukherjee is here.
My senior Mr. Amit Kumar, assist here. He's on next before.
What is this? What is the ground for your appeal? Tell me. You are the insurance company.
Yes, sir.
What are the grounds of your appeal?
The income has been assessed without any evidence. The income has been assessed at rupees 9,000 per month.
He was a barber.
Yes, sir. It was a barber.
So the barber, you mean to say the barber cannot earn 300 rupees a day? A barber cannot earn 300 rupees a day.
There was no evidence left to that.
So he was a barber, that is admitted. Did you deny the fact that he was a barber?
No.
Then?
Further, we have also studied the exorbitant amount has been given towards loss of control.
Let's come to that. Where is it? Where is this?
That is
How much?
That is in the page number 19 or
Let us see page number 19. How much has been granted?
1 lakh has been added as loss of
Future prospect has been given?
Future prospect has been given as 30%. It should be 40%.
It should be 40%.
Other things are in order to meet the consortium part. Consortium part, 1 lakh rupees, 1 lakh, another 1 lakh for loss of estate and 3 lakh for loss of love and affection.
Total how much?
5 lakhs, Your Honor.
Total 5 lakhs.
Yes, Your Honor.
Yes.
The right calculation, the amount of right calculation would come to 19,97,800, which would be 9,000 into 12 into the element multiplied 17, the inverse 26 plus 40% future profits less 1/4 because number of dependents is the same. plus 70,000, if we add 70,000 only, then it will come to 19,97,000.
19,97,000.
800.
The direct interest, your lordship, 23,65,000.
So he is saying that 19,97,000 plus interest how much?
Lordship,
7.5 from the date of filing of the
penal
application.
interest is of lordship.
Penal interest, okay, I'll waive it. So pay the amount.
Lordship, the amount has been deposited, your lordship.
Which amount?
IAF was stay, your lordship. And the stay was subject to the deposition of rupees 25 lakhs, your lordship.
25 lakhs. So
15 lakh was directed to be disbursed to the claimants.
So it's 19,97,800. How much the interest comes to? From the date of filing till the date of depositing?
Interest for 1 year would be around 1,49,835.
On 19,97,000.
On 19,97,000.
How many years?
In the case of 2013.
13, and it was deposited when?
The order was.
Mr. Das, the claimant says that the actual amount will come to 19,97,800. I am not interfering in the income. 9,000.
Barber in the village, 9,000 rupees was only 300 rupees purchase is the total evidence. So
9,000 rupees. Maintaining so many.
in case of carpenter, the amount has earlier also the 5,000 to 6,000.
9,000 it's okay.
And secondly, the pay and recovery for your
Yes.
pay and right of recovery. Because also taken into consideration, we had challenged the owner, your lordship did not bring any document on record. And this is the finding at para 10.
Owner has appeared or not?
Owner appeared. But the court says that owner has stated that he was having valid license and therefore owner is on the insurance company.
No, owner has produced.
No, and this
Where is the FCI?
although the
How much you have deposited? How much you have deposited?
So there was a direction to deposit 25 lakhs.
Yes.
The lordship says order dated 13/6/2018.
You have withdrawn how much?
15 lakhs was directed to be disbursed. 10 lakhs was.
Para 10 of the judgment is also contrary to the judgment that on law around the government.
Yes.
Para 10 of the judgment.
What is it?
It says your lordship that though he had challenged that the driver did not have valid license, barely because the OP number 1 in his written statement had stated the driver had a valid license, and we did not need any evidence to prove that he did not have, and therefore owner's response was on us as per the judgment. Wherein it has specifically stated that initial burden is on the owner of the vehicle.
You have withdrawn how much?
15 lakhs has been directed to be disbursed.
Just check the calculation whether it is 19,97,000. It is on 9,000. Mr. Das, you check it. He said 19,97,000.
9,000 into 12 to 1,80,000 plus 40% plus only 1/4 has to be deducted.
1/4.
Yes, so 3/4 will be
How much?
into 12 into 17. 17 would have been multiplied would be 18,36,000. 18 divided by 4 into 3 would be 13,77,000 plus 40% would be 19 lakh plus would be 19,27,800 plus 70,000 would be 19,97,800.
What should we do? 9,000 into 12 is 1,08,000. But 1,08,000 if we multiply by 3/4. So 1/4 is personal expenses. It will come to 81,000. What should
Multiply?
81,000 plus 40% 81,000 teacher prospects 32,000. 1,13,000. 1,13,000 into multiplier has been given of 12.
Multiplier 70.
Then I am using the wrong.
It was 20.
19,21,000 plus
70,000. How much?
19,91.
It would be 9,000. 9,000.
9,000, calculate with me. 9,000 into 12 into 17 equals to 18,36,000
Yes.
less 1/4. That means into 3 divided by 4 equals to 13,77,000. No issue.
Yes, no issue. That's what.
Plus 140%. 19,27,800.
Plus 70,000.
Yes. Plus 70,000.
1990.
Plus 70,000, how much? 1997 800. So as per him, 1997 800.
Considering the income is 9,000.
Counsel for the appellant in this case has submitted that the income of the deceased could not have been considered to be 9,000 per month. He further submits that the right to recovery should have been awarded in favor of the insurance company, as the owner of the vehicle has failed to discharge the primary onus in respect of the documents of the vehicle and the driving license of the driver. Next paragraph. Considering his submission, this appeal is admitted for hearing. Issue notice to the, who is the owner? Who is the owner?
Respondent number 6.
Issue notice to respondent number 6, registered ordinary, both process. Requisites 3 weeks. Full stop. Next para. In the meantime, the claimants will be at liberty to withdraw a further sum of rupees. How much we have withdrawn?
15 lakh.
How much left?
4 lakh
10 lakh rupees.
The entire amount.
With interest. That has been included as interest also. Call for the local records.
Withdraw the outstanding amount.
10 lakhs. You have deposited 10 lakhs.
Yes, yes.
10 lakh is there. 10 lakhs. Deposit amount of rupees 10 lakhs. You will get something more if 9,000, because you have this interest which I have calculated is from the date of application till the award.
Yes.
Now from award till deposit there will be some amount.
25 lakh, deposit considering that income cannot be 9,000. Because even if we go by what the court has accepted, 300 rupees per day, so he will not work for all 30 days of say 50 days of
Most probably you go to a very good salon, Mr. Das. Don't tell this, Mr. Das.
There are 2 parts, one matters and 2.
I see you in Habib's. Yes.
2 parts, one matters and 2 admission matters left.
Call
Admission matters are part.
admission, continue.
Serial number 34, MA number 548 of 16, Mr. A.S. Dayal.
Yes. Why?
On the ground that at the time of accident, he had to stay due to the reason that there was some mechanical fault in the vehicle. And then
Which vehicle?
someone vehicle.
And you are the?
I was sitting in that vehicle which was along with the family members returning from marriage. In that due course of the accident took place. And 2 of the family members have also been sustained injuries. People are still in the finding of the next. Paragraph number 53 of this.
This vehicle was being used for hire or reward? For hire. This vehicle was a.
That is clear from the present record, from the judgment, and only the fact that this was returning from a marriage.
No, what was the nature of the vehicle? What was the registration of this vehicle? It was a commercial vehicle. Let us see the judgment.
Page 20, sir. Paragraph number 2. The case of the claimant is that on 25/2008, when father, Jeet Nagesha, and other villagers had gone to attend marriage ceremony, and when they were returning to home by Sawari vehicle number J073 and when they reached near the Amberadi PS Parko, then due to rash and negligent driving of driver, operating vehicle dashed to mango tree, and several passengers were injured, and on the basis of Pathan of Ajay Nagesha, case under section 279, 337, 338, 304 capital NBC was instituted against the driver of the Sawari vehicle number 6. Commercial and was also restored. The deceased was aged about 50 years at the time of accident.
Who is the owner?
Yes, sir.
Who is the owner of the vehicle? Did you appear before the tribunal? Did you appear before the tribunal?
Yeah.
You filed your written statements. Where is your written statement?
Paragraph number 6. Paragraph number.
Let me see the written statement. Purushottam Singh. What is the ground of denying compensation?
The rejection of the claim application is mainly on the evidence of given witness number 2 and 3.
2 and 3.
2 and 3. Because they are the eyewitnesses and they have stated that there is no negligence or rashness on the part of the driver of the vehicle.
How?
And in the charge sheet, the negligence was there on the part of the driver. But as because on the witness box, this witness number 2 and 3 has stated the vehicle was in slow speed and going slowly and like that. Therefore, the court below has said as because the rash and negligence driving.
Just driving at a high speed shows rash and negligence. Only driving a vehicle at a high speed will attract rash and negligence act.
Considering the entire evidence.
Let us see the evidence.
May I submit perhaps the LCR will be required.
It's here.
that cannot
see. But let us see what is the evidence. The evidence is only one line, which you are saying. One paragraph, only one paragraph he says, the driver गाड़ी तेजी और लापरवाही से नहीं चला रहा था. Check this. Now, give it to Mr. Bush. Read this evidence. Now it is an admitted case. The vehicle dashed with a tree, resulting in injuries of many and death of one. So how do you correlate this statement with the nature of accident?
In this case, only one thing is to be considered. That from the record is appearing the accident took place due to mechanical cause.
From where are you getting this?
From the judgment.
From where? You read the evidence?
Yes.
That's why I have given you the evidence. You read the next one also, PW3.
Yes.
Read that. Read that.
गाड़ी धीरे चल रही थी और गाड़ी में गड़बड़ी के कारण आम के घास में रखा गया.
Show that whether the MBA report has been exhibited. Now, if you say that there was a mechanical fault, then is it not a rash and negligent act on your part to ply the vehicle with a mechanical fault?
I have been provided with recovery license. It is the owner who can say. On the top of permit, right of recovery has been given to me.
Recovery has been given to you.
Yes.
So the court has dismissed the claim. How can the right of recovery be given to you?
Yes. That is paragraph 29, turning page 26.
Okay, we'll hear this after 4 weeks. Admit this case after 4 weeks under the heading for hearing. Yes. Let's see. Let's see. Date of accident? Okay. It was abolished on 2006-7. It was reintroduced on 2019-20. So इसमें लिखिए audit part further tomorrow. Tomorrow.
Supplementary.
Yes, give the supplementary list. Only for the calculation, how much is the interest.
In item number 16 matters, order that nobody appears at the past matters. I was regularly appearing this case matters.
I don't know, today no one appears.
Matters. I was in court number 9 matters. That serial number 18 matters. I was sitting here in the morning matters.
No one appeared.
Yes, this matters. No one appeared, but I was in court.
Serial
I was
number
in court number 18 matters. I was
serial
sitting-
number?
This item number 16 matters. I was regularly appearing in this case matters. On last occasion also I had appeared matters. On behalf of
Serial number?
number 1 and 2 matters. Serious service of notice has been given.
What is the order?
Because we should notice.
You should notice.
Press steps for notice.
Order is that nobody appears. Press service of notice is
Yes.
taken.
So nobody appears. Fresh service, you take service. No one appeared at that point of time.
My-
But
I was